integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the State Constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination, as understood by the definition of sovereignty, exists by which the state is subordinate to the Indian Constitution first and only then to its own constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Call was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the Dominion of India did not arise in that case. The next issue which we have addressed is the challenge to Constitutional Order 273, CO 273. To answer this issue, we had to decide on two issues. One, whether Article 370 is a temporary provision, and two, the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370. We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve two purposes. First, the transitional purpose, to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. C. We have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution. D. On the second question of the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370, we have held that the power of the President of India under Article 370, Clause 3, to issue a notification declaring that Article 370 ceases to exist, subsists even after the dissolution of the Constituent Assembly of Jammu and Kashmir for the following reasons. First, the proviso to Article 373, that is Clause 3, encapsulates the process by which the Indian states could ratify the Constitution of India. The ruler of each Indian state had to issue a proclamation ratifying the Constitution on the recommendation of the Constituent Assembly, where such body existed. In states where the Constituent Assembly was not convened by then, the ruler of the state had to issue a proclamation accepting the Constitution. When a Constituent Assembly was convened in those states, the Constituent Assembly could make a recommendation for the modification of the Constitution as it applied to the state and such a recommendation would be earnestly considered, into inverted commas, earnestly considered by the Union. The words recommendation of the Constituent Assembly, referred to in Clause 2, shall be necessary before the President issues a notification, as it appears in the proviso to Article 370, Clause 3, and must be read in this context. Thus, the recommendation of the Constituent Assembly to begin with was not binding on the President. Second, at the time of the framing of the Constitution of India, it was obviously within the contemplation that the Constituent Assembly of Jammu and Kashmir was formed for framing the Constitution for the state. It was not intended to be a permanent body, but a body with a specific remit and purpose. The power conferred by the proviso to Article 370, Clause 3, was hence something which would operate in a period of transition when the Constituent Assembly of Jammu and Kashmir was formed and was in existence pending the drafting of the state constitution. Third, when the Constituent Assembly of Jammu and Kashmir ceased to exist, only one of the special circumstances for which the provision was introduced ceased. However, the other circumstances, that is, the special circumstances because of the situation in the state of Jammu and Kashmir, for which Article 370 was introduced, subsisted even after the Constituent Assembly ceased to exist.
1501 for judgment.
I'll read out the essence of the judgment. There are three judgments of this court. One authored by the Chief Justice for himself, Justice Gavai and Justice Suryakant. There is a concurring opinion authored by Justice Sanjay Kaul. Justice Sanjeev Khanna has concurred with both the judgments. The reference before the Constitution bench raises the following questions for determination. A, whether the provisions of Article 370 were temporary in nature or whether they acquired a status of permanence in the Constitution. B, whether the amendment to Article 367 and exercise of the power under Article 371D so as to substitute the reference to the Constituent Assembly of the state referred to in Clause 3 of Article 370 by the words Legislative Assembly of the state is constitutionally valid. C, whether the entire Constitution of India could have been applied to the state of Jammu and Kashmir in exercise of the power under Article 370, Clause 1, bracket D. D, whether the abrogation of Article 370 by the President in exercise of the power under Article 370, Clause 3 is constitutionally invalid in the absence of a recommendation of the Constituent Assembly of the state of Jammu and Kashmir as mandated by the proviso to Clause 3. E, whether the proclamation of the Governor dated 20 June 2018 in exercise of power conferred by Section 92 of the Constitution of Jammu and Kashmir and the subsequent exercise of power on 21 November 2018 under Section 53(2) of the Constitution of Jammu and Kashmir to dissolve the Legislative Assembly are constitutionally valid. F, whether the proclamation which was issued by the President of India under Article 356 of the Constitution on 19 December 2018 and the subsequent extensions are constitutionally valid. G, whether the Jammu and Kashmir Reorganization Act 2019, by which the state of Jammu and Kashmir was bifurcated into two union territories, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh, is constitutionally valid, bearing in mind, 1, the first proviso to Article 3, which requires that a bill affecting the area, boundaries, or name of a state has to be referred to the legislature of the state for its views. And 2, the second proviso to Article 3, which requires the consent of the state legislature for increasing or diminishing the area of the state of Jammu and Kashmir, or altering the name of the boundary of the state before the introduction of the bill in Parliament. H, whether during the tenure of a proclamation under Article 356, and when the Legislative Assembly of the state is either dissolved or is in suspended animation, the status of the state of Jammu and Kashmir as a state under Article 13A of the Constitution and its conversion into a union territory under Article 13B constitutes a valid exercise of power. I'll now read out our conclusions under different heads. Whether the proclamation issued under Article 356 of the Constitution of India and Section 92 of the Constitution of Jammu and Kashmir is constitutionally valid. We have held that this court need not adjudicate on the validity of the proclamations because, 1, the pleadings of the petitioners in the writ petitions indicate that their principal challenge is to the abrogation of Article 370 and whether such an action could have been taken during Precedent's rule. And 2, even if this court holds that the proclamation could not have been issued under Article 356, there would be no material relief which can be given in view of the fact that Precedent's rule was revoked in the state of Jammu and Kashmir on 31st October 2019. Further, the petitioners have assailed the specific actions which were taken when the proclamation was in force on the ground that those actions breached the constitutional limitations on the exercise of power after a proclamation under Article 356 is issued. These substantive challenges, which form the fulcrum of the case of the petitioners, have been considered. Next issue, whether there are limitations on the exercise of power by the President or Parliament under Article 356. We have held that there are limitations on the power which can be exercised by the Union government in the state when a proclamation under Article 356 is in operation. We have reached the conclusion on the following grounds. A, the majority in S.R. Bommai, the 9-judge bench decision, held that the actions taken by the President after issuing a proclamation are subject to judicial review. However, the learned judges adopted slight variations on the standard needed to be applied by the court to test the validity of the exercise of power by the President after the issuance of the proclamation. Justice Sawant applied the standard of whether the exercise of power was mala fide or palpably irrational. Justice Reddy observed that the advisability and necessity of the action must be borne in mind by the President. 2. This bench, sitting in a combination of 5 judges, is bound by the decision of the majority in S.R. Bommai on the issue. We also undertook a textual and purposive reading of Article 356 in particular and Part 18 as a whole. We hold that there are limitations on the power exercisable after a proclamation under Article 356 is issued. The following are our reasons. First, the thread that runs through Part 18 of the Constitution, when read as a whole, is that differing levels of executive and legislative power are required to handle an emergency under Article 352 and under Article 356. This principle applies to the exercise of power when a proclamation under Article 356 is in force. Second, Article 356(1) states that the President may, by a proclamation, assume or declare the powers stipulated in clauses A, B, and C of Article 356(1). The powers stipulated in clauses A, B, and C of Article 356(1) are not automatically invoked when a proclamation is issued under Article 356. Third, Article 356(1)A does not opt for an all or none formula. The phrase all or any does not indicate that the union government can exercise a part of the functions of the state government and the state government can exercise the remaining, because the suspension of the state government is an automatic consequence of the proclamation under Article 356. It rather indicates that the scope of the power exercised by the union government must depend on the circumstances for issuing the proclamation. Fourth, clauses A, B, and C of Article 356(1) grant the President independent powers. However, the power provided under Clause C is broad enough to encapsulate the power of the President to assume functions under Clause A and declare under Clause B that the powers of the legislature of the state shall be exercisable by Parliament. Fifth, the principle underlying Article 356(1)(c) is that the exercise of power by the President must be desirable or necessary to give effect to the objects of the proclamation. The commonality in both the necessity and desirability standard is that the exercise of power must have a reasonable nexus with the object of the proclamation. Thus, the principle which runs through Article 356(1)(c) and which also guides the exercise of power under Article 356(1)(a) is that the exercise of power must have a reasonable nexus with the object of the proclamation. And sixth, when a proclamation under Article 356 is in force, there are innumerable decisions which are taken by the union government on behalf of the state government for the purpose of day-to-day administration. Every decision and action taken by the union executive on behalf of the state is not subject to challenge. Opening up challenge to every decision would lead to chaos and uncertainty. It would in effect put the administration in the state at a standstill. Therefore, the following standard is laid down to assess actions under Article 356 after the proclamation has been issued. A. The exercise of power by the President under Article 356 must have a reasonable nexus to the object of the proclamation. B. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. After a prima facie case is made, the onus shifts to the union to justify that the exercise of power had a reasonable nexus with the object of the proclamation. And C, the exercise of power by the President for everyday administration of the state is not ordinarily subject to judicial review. The argument of the petitioners that the union government cannot take actions which have irreversible consequences when a proclamation under Article 356 is in force is not accepted. The power of the legislature of the state under Article 357 to repeal or alter or amend a law enacted by Parliament in exercise of the power of the legislature of the state must be read in the context of the amendment introduced by the Constitution 42nd Amendment Act 1976. Before the amendment, the law to the extent of incompetency would automatically cease to exist after a buffer period and actions done were expressly saved. However, an express repeal by the competent legislature is required for the law to cease to exist after the amendment. The repealing statute would, in such case, make provisions for actions taken during the subsistence of the legislation. The observations in Krishna Kumar Singh on whether the consequence of an ordinance can subsist even after the ordinance ceases to exist cannot be transposed to interpret the limits of Article 356 because an ordinance which has the effect of a law by its very nature has a limited life. The argument of the petitioners that Parliament can only assume the lawmaking powers of the legislature of the state when the proclamation under Article 356 is issued is not accepted. The purpose of Article 357 is to ensure that while exercising the powers of the legislature of the state, pursuant to a declaration under Article 356(1), Parliament, or as the case may be, the President, are not impeded by an absence of competence which would have impeded the exercise of a similar power in the absence of a proclamation under Article 356. Further, Article 357 does not contain a non-obstante provision which overrides Article 356. To interpret Article 357(1) as a restriction on Article 356(1)(b would be to read in a restriction which the plain terms of the Constitution do not provide. As held above, the exercise of power after a proclamation under Article 356 is issued is subject to judicial review, and immunity from judicial scrutiny does not attach to the exercise of constitutional powers of the legislature of the state. The court, while judicially reviewing the exercise of power, can determine if the exercise of the constitutional power of the legislature of the state by Parliament has a reasonable nexus with the object sought to be achieved by the proclamation. The next issue is whether Jammu and Kashmir retained an element of sovereignty or internal sovereignty when it joined the Union of India. We have held that the state of Jammu and Kashmir did not retain an element of sovereignty when it joined the Union of India. We have arrived at this conclusion for the following reasons. First, paragraph 8 of the instrument of accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. The declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state which were inconsistent with it, but also abrogate them, achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the instrument of accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. Third, neither the constitutional setup nor any other factors indicate that the state of Jammu and Kashmir retained an element of sovereignty. The Constitution of Jammu and Kashmir was only to further define the relationship between the Union of India and the state of Jammu and Kashmir. The relationship was already defined by the instrument of accession, the proclamation by Yuvraj Karan Singh in November 1949, and more importantly, by the Constitution of India. Fourth, there is a clear absence in the Constitution of Jammu and Kashmir of a reference to sovereignty. In contrast, the Constitution of India emphasizes in its preamble that the people of India resolve to constitute themselves or to constitute India into a sovereign, socialist, secular, democratic republic. Fifth, that the state of Jammu and Kashmir became an integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the State Constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination as understood by the definition of sovereignty exists by which the state is subordinate to the Indian Constitution first and only then to its own constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Call was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the dominion of India did not arise in that case. The next issue which we have addressed is the challenge to Constitutional Order 273, CO 273. To answer this issue, we had to decide on two issues. One, whether Article 370 is a temporary provision, and two, the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370. We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve two purposes. First, the transitional purpose, to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession, and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. C. We have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution. D. On the second question of the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370, we have held that the power of the President of India under Article 370, Clause 3, to issue a notification declaring that Article 370 ceases to exist, subsists even after the dissolution of the Constituent Assembly of Jammu and Kashmir for the following reasons. First, the proviso to Article 373, that is Clause 3, encapsulates the process by which the Indian states could ratify the Constitution of India. The ruler of each Indian state had to issue a proclamation ratifying the Constitution on the recommendation of the Constituent Assembly, where such body existed. In states where the Constituent Assembly was not convened by then, the ruler of the state had to issue a proclamation accepting the Constitution. When a Constituent Assembly was convened in those states, the Constituent Assembly could make a recommendation for the modification of the Constitution as it applied to the state, and such a recommendation would be earnestly considered, into inverted commas, earnestly considered by the Union. The words recommendation of the Constituent Assembly, referred to in Clause 2, shall be necessary before the President issues a notification, as it appears in the proviso to Article 370, Clause 3, and must be read in this context. Thus, the recommendation of the Constituent Assembly to begin with was not binding on the President. Second, at the time of the framing of the Constitution of India, it was obviously within the contemplation that the Constituent Assembly of Jammu and Kashmir was formed for framing the Constitution for the state. It was not intended to be a permanent body, but a body with a specific remit and purpose. The power conferred by the proviso to Article 370, Clause 3 was hence something which would operate in a period of transition when the Constituent Assembly of Jammu and Kashmir was formed and was in existence pending the drafting of the state constitution. Third, when the Constituent Assembly of Jammu and Kashmir ceased to exist, only one of the special circumstances for which the provision was introduced ceased. However, the other circumstances, that is, the special circumstances because of the situation in the state of Jammu and Kashmir, for which Article 370 was introduced, subsisted even after the Constituent Assembly ceased to exist. This is recognized by the judgment of the Constitution Bench in Sampat Prakash. Fourth, the effect of the President declaring under Clause 3 of Article 370 that Article 370 ceases to exist is that the provisions of the Constitution which apply to every state in the first schedule would equally apply to the state of Jammu and Kashmir. Articles 370(1)(d) and 370(3) were introduced with the purpose of enhancing constitutional integration and not for the disintegration. So, the power under Article 370(1)(d) and Article 370 Clause 3, even when exercised to its fullest extent, does not freeze the system of integration contemplated by Article 370, but is rather intended to enhance constitutional integration between the Union and the state of Jammu and Kashmir. Holding that the power under Article 370 Clause 3 cannot be exercised after the dissolution of the Constituent Assembly would lead to the freezing of the process of integration, contrary to the purpose of introducing the provision. And 5, if the contention of the petitioners on the interpretation of Article 370 vis-a-vis the dissolution of the Constituent Assembly is accepted, then Article 370 Clause 3 would become redundant and would lose its temporary character. The President, while deciding if the power under Article 370 Clause 3 must be exercised, determines if the special circumstances which warranted a special solution in the form of Article 370 have ceased to exist. This is a policy decision which completely falls within the realm of the executive. The court cannot sit and appeal over the decision of the President of India on whether the special circumstances which led to the arrangement under Article 370 have ceased to exist. However, the decision is not beyond the scope of judicial review. It is settled law that the exercise of executive power can be challenged on the ground of malafides. The slew of constitutional orders issued by the President under Article 370(1)(d, applying various provisions of the Constitution and applying provisions with modification, indicate that over the course of the last 70 years, the Union and the state have, through a collaborative exercise, constitutionally integrated the state of Jammu and Kashmir with the Union. This is not a case where only Articles 1 and Article 370 of the Constitution were applied to the state of Jammu and Kashmir, and suddenly, after 70 years, the entire Constitution was being made applicable. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President in exercise of the power under Clause 3 of Article 370 is a culmination of the process of integration. Thus, we do not find that the President's exercise of power under Clause 3 of Article 370 was mala fide. Having concluded that the power under Article 370, Clause 3 subsisted even after the dissolution of the Constituent Assembly, we have held that the exercise of power by the President to issue CO 273 is a valid exercise of constitutional power. The next issue is the challenge to CO 272 on the ground that the power under Article 371(d) cannot be issued to apply all the provisions of the Constitution to the state of Jammu and Kashmir. We have held that all provisions of the Constitution can be applied to Jammu and Kashmir through the exercise of power under Article 371(d). The power under Article 371(d) can be used to apply one provision, more than one provision, an entire part of the Constitution, or all the provisions of the Constitution, that is the entire Constitution. The provision does not make a distinction between one or all provisions of the Constitution. Non-application of mind cannot be claimed merely because CO 272 applies all provisions of the Constitution to Jammu and Kashmir in one go. The next issue is the challenge to CO 272 on the ground that the President could not have secured the concurrence of the Union government under the second proviso to Article 371D. We hold that the President seeking the concurrence of the Union government instead of the government of the state to issue CO 272 is not invalid because, first, the effect of applying all the provisions of the Constitution to the state of Jammu and Kashmir through the exercise of power under Article 371D is the same as an exercise of power under Article 370, Clause 3, notifying that Article 370 shall cease to exist. That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir, except for the fact that the former can be reversed while the latter, namely under Clause 3, cannot. Second, consultation and collaboration between both the units will only be necessary where the application of the provisions of the Indian Constitution to the state would require amendments to the state constitution, because the purpose of the requirements of consultation and collaboration is for the smooth functioning of governance in the state and to ensure that the provisions of the Constitution of Jammu and Kashmir are not inconsistent with the provisions of the Constitution of India. Third, since the effect of applying all the provisions of the Constitution of Jammu and Kashmir, to Jammu and Kashmir through the exercise of the power under Article 371D is the same as issuing a notification under Article 370, Clause 3, which the President has the power to unilaterally issue, the principle of consultation and collaboration are not required to be followed. Fourth, the exercise of power is mala fide only if power was exercised with an intent to deceive. Deception can only be proved if the power which is otherwise unavailable to the authority or body is exercised, or if the power that is available is improperly exercised. Since the concurrence of the state government was not required for the exercise of power under Article 370(1)(d) to apply all provisions of the Constitution to the state, the President securing the concurrence of the Union of India on behalf of the state government is not mala fide. The next issue is the challenge to CO 272 on the ground that it is ultra vires Article 371D because it modifies Article 370. We have held that the modification by CO 272 to Article 367 as it applies to Jammu and Kashmir had the effect of amending Article 370 and is thus ultra vires Article 370(1)(d). We have reached this conclusion for the following reasons. First, recourse must be had to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. No other procedure may be utilized to amend Article 370. Second, the rule of interpretation that a power under a statute must be exercised in accordance with the provisions of that statute and in no other manner is undoubtedly applicable to the Constitution. Third, from precedent, including Shankari Prasad Singh, Sajjan Singh, Quixote Holohan, and Rajendra Shah, it emerges that the following aspects are of significance when assessing whether a change has been made to a provision of the Constitution. One, a change may be either in terms of or in its effect. Two, a change can be said to have been made even if the language of the concerned provision is not directly amended by adding, subtracting, or modifying the language. This is a change in effect. And three, if the effect of an amendment is to change a provision, such effect must be significant or appreciable. And four, the substance of a change is more important than its form. Second, an assessment of whether a constitutional order amounts to a modification and consequently whether the procedure under Article 370, Clause 1 or under Article 370, Clause 3 ought to have been followed depends on this standard. Third, the effect of a provision of law is as important as its form. While the change sought to be made by paragraph 2 of CO 272 may appear to be a modification or amendment of Article 367 at first blush, its effect is to amend Article 370 itself. CO 272 changes the language to the proviso to Article 370, Clause 3 in two ways. First, it changes the recommending body from the Constituent Assembly to the Legislative Assembly. And second, it makes a new arrangement at variance with that specific Constituent Assembly. Both these changes are not insignificant because they modify the essential character of the proviso by substituting a particular type or kind of body with another type or kind entirely. Fourth, while the interpretation clause, namely Article 367, can be used to define or give meaning to particular terms, it cannot be deployed to amend a provision by bypassing the specific procedure laid down for its amendment. This would defeat the purpose of having a procedure for making an amendment to the Constitution of India. Fifth, the consequence of permitting amendments through the circuitous manner would be disastrous. Many provisions of the Constitution would be susceptible to amendments which evade the procedure stipulated by Article 368 or other provisions. Sixth, the previous constitutional orders which modified Article 370 through Article 367 were clarificatory and consequential. They did not have the effect of amending Article 370. We have therefore held as ultra vires the amendments which were made to Article 370, Clause 3 by taking recourse to Article 367. G, the status of the Constitution of Jammu and Kashmir. The gaps left by the non-application of some parts of the Constitution of India were filled by the Constitution of the state. After the abrogation of Article 370, as it stood before the issuance of CO 272 and CO 273, and the application of the entirety of the Constitution of India to the state, the Constitution of the state does not fulfill any purpose or serve any function. Hence, the implicit but necessary consequence of the application of the Constitution of India in its entirety to the state of Jammu and Kashmir is that the Constitution of the state is inoperative. On the validity of Parliament's exercise of power under the first proviso to Article 3, this is what we have said. A five-judge bench of this court in Babulal Parate held that the views expressed by the legislature of the state under the proviso to Article 3 are not binding on Parliament. If the views of the state legislature were binding on Parliament, which is not the case, there would be scope for debate on whether Parliament, in exercise of its powers under Article 356(1)(b), could have substituted its views for the views of the Legislative Assembly of the state. However, the views of the legislature of the state are not binding on Parliament in terms of the first proviso to Article 3. The views of the legislature of the state under the first proviso to Article 3 are recommendatory to begin with. Thus, Parliament's exercise of power under the first proviso to Article 3 is valid and not mala fide. The next issue is on the validity of the suspension of the second proviso to Article 3 as applicable to Jammu and Kashmir. When the reorganization bill was introduced, that is on 5 August 2019, the second proviso to Article 3 as it applied to the state of Jammu and Kashmir ceased to exist because of CO 272. Thus, the issue of whether the second proviso to Article 3 could have been suspended in exercise of the power under Article 356(1)(c) does not survive. The next issue is the validity of the Jammu and Kashmir Reorganization Act 2019. The Solicitor General, appearing for the Union of India, submitted that statehood will be restored to Jammu and Kashmir and that its status as a union territory is temporary. The Solicitor General submitted that the status of the Union Territory of Ladakh will not be affected by the restoration of statehood to Jammu and Kashmir. In view of the submission made by the Solicitor General that statehood would be restored of Jammu and Kashmir, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. The status of Ladakh as a union territory is upheld because Article 3A, read with explanation 1, permits forming a union territory by separation of a territory from any state. This court is alive to the security concerns in the territory. Direct elections to the legislative assemblies, which is one of the paramount features of representative democracy in India, cannot be put on hold until statehood is restored. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible. The question of whether Parliament can extinguish the character of statehood by converting a state into one or more union territories in exercise of power under Article 3 is left open. In an appropriate case, This court must construe the scope of powers under Article 3 in light of the necessary effect of converting a state into union territories, which is that autonomy would be diminished, the historical context for the creation of federating units, and its impact on the principles of federalism and representative democracy. In view of the above discussion, the following are the conclusions. A. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the instrument of accession and the issuance of the proclamation dated 25 November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. B. The petitioners did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to the proclamations does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. C. The exercise of power by the President after the proclamation under Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of the proclamation. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. Once a prima facie case is made, the onus shifts to the union to justify the exercise of such power. D. The power of Parliament under Article 356(1)(b) to exercise the powers of the legislature of the state cannot be restricted to lawmaking power, thereby excluding non-lawmaking power of the legislature of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article. E. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. F. The power under Article 370, Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the provisor to Article 370, Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370, Clause 3. G. Article 370 cannot be amended by exercise of power under Article 370(1)(d). Recourse must have been taken to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. Paragraph 2 of CO 272, by which Article 370 was amended through Article 367, is ultra vires Article 370, Clause 1, Clause D, because it modifies Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. H. The exercise of power by the President under Article 370(1)(d) to issue CO 272 is not mala fide. The President, in exercise of power under Article 370, Clause 3, can unilaterally issue a notification that Article 370 ceases to exist. The President did not have to secure the concurrence of the government of the state or union government acting on behalf of the state government under the second provisor to Article 370(1)(d) while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Clause 3 of Article 370, for which the concurrence or collaboration with the state government was not required. I. Paragraph 2 of CO 272 issued by the President in exercise of power under Article 370(1)(d), applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not mala fide, merely because all the provisions were applied together without following a piecemeal approach. J. The President had the power to issue a notification declaring that Article 370, Clause 3 ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370, Clause 3 is a culmination of the process of integration and as such is a valid exercise of power. Thus, CO 273 is valid. K. The Constitution of India is a complete code for constitutional governance. Following the application of the Constitution of India in its entirety to the state of Jammu and Kashmir by CO 273, the Constitution of the state of Jammu and Kashmir is inoperative and is declared to have become redundant. L. The views of the legislature of the state under the first proviso to Article 3 are recommendatory. Thus, Parliament's exercise of power under the first proviso to Article 3 under the proclamation was valid and not mala fide. M. The Solicitor General stated that the statehood of Jammu and Kashmir will be restored, except for the carving out of the Union Territory of Ladakh. In view of the statement, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two Union Territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, we uphold the validity of the decision to carve out the Union Territory of Ladakh in view of Article 3A, read with Explanation 1, which permits forming a Union Territory by separation of a territory from any state. N. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible.
So I begin from a different way, from the history of Kashmir, traced out the history of Kashmir, relying on the contextual text of Rajtarangni and Bamzai's on culture and political history of Kashmir. Thereafter, I proceeded to analyze the circumstances in which Jammu and Kashmir Constitution Act of 1939 came into being, and then considered the submissions under different heads. Read out my conclusion. More or less, the conclusions are same, except in one of the aspects of Premnath's case, I have taken a slightly different route. That's all. So, the relationship between Union and State of Jammu and Kashmir, the concept of internal sovereignty after the IO. I am of the view that this question has been decided by the coordinate bench of this court in Premnath's call that the state did not lose all semblance of its internal sovereignty, which would include deciding upon the forms of government of the state upon signing of the IO. The distinguishing feature as compared to the other states was that a slightly different path was followed for the accession of state of Jammu and Kashmir by recognizing the Constituent Assembly to be formed for the state. The route of assimilation of state of Jammu and Kashmir was through Article 370. Then I've heard that I've taken note of the various factors such as Article 370's historical context in the text and subsequent practice to conclude that Article 370 was intended to be a temporary provision. As a corollary, there was a mechanism to bring the whole arrangement to an end. The effect of the power under Article 373, once exercised, would be that the article shall cease to be operative. In other words, the mechanism was meant to de-recognize the state's internal sovereignty Thus, the exercise of power under Article 373 meant that for purposes of the Constitution of India, only the Constitution of India would apply to the Jammu and Kashmir and not any other constitution, that is the Constitution of Jammu and Kashmir. The purpose, then on Article 373, I have said, the purpose of the Constituent Assembly was to draft a constitution for the governance of the state. On the other hand, the purpose of Article 370, as noted above, was to slowly bring Jammu and Kashmir on par with the states in India. It can hardly be contended that the second and in some ways a larger purpose would be effected by the fulfillment of the first. The second purpose remained an ongoing exercise long after the State Constituent Assembly was dissolved. Thus, the conditionality in Article 373 of the requirement of a recommendation from Constituent Assembly cannot be read in the manner as to make the reference to the larger intention of the provision redundant. B. The next question is to determine what process is to be followed by the President to exercise the power under Article 373. The President can exercise this power under Subclause 3 without a recommendation from the Jammu and Kashmir Constituent Assembly. When the Constituent Assembly ceased to exist, only the power of the Constituent Assembly to make the recommendation ceased to exist. That is, the proviso to Article 370 became odious. The main provision, which is the President's power to issue a declaration, continues to exist. C. Now coming to the impugned action, first the amendment of Article 373 through the route of Article 367 was invalid. When a methodology has been provided, that methodology would have to be followed and an amendment through the back door would be impossible. D. Concurrence with the government of the state was not necessary to apply all provisions of the Constitution of India to the state. Although Article 371D requires concurrence with government of the state, in this case, the governor of the state had dissolved the Legislative Assembly of the state. There were no Council of Ministers, and the President had reduced to himself all functions of the government of the state under the 2018 proclamation as extended. Then on the exercise of power under Article 356 were permissible while issuing COs 272 and 273. Article 356 can be imposed once the Legislative Assembly has been dissolved, particularly since Section 92 of the Jammu and Kashmir Constitution limited the governor's role to 6 months without any scope to extend. This imposition was predicated on the failure of the constitutional machinery, which really took place prior to the government's rules.
ये दुनिया भर में घूमते भटकते लाइफ एंजॉय करते हुए बिजनेस बिल्ड नहीं होता. लेट मी प्रूव यू रॉन्ग. Hiten Panchal runs a distribution business of safety products and he goes on week-long safaris. Gautam Shah runs an IT service business and takes 7 days off every month. Anil Parmar, manufacturer LED lights, has started going on vacation with his family every damn year. And you know what's the best part? All of them have grown their business revenues more than 50%. I know you must be wondering, this can't be real. Well, don't trust my words. Try it out yourself. Because I am going to share the step-by-step framework that will help more than 100,000 business owners in growing and scaling their business profitably using the Entrepreneur to Wealth Challenge formula. Hi, my name is Dr. Arvind Parekh. I'm a senior.
Then B, Article 356 permits the President to make irreversible changes. Both Savanji and Reddy J and S.R. Momai recognize that irreversible actions in this case, the de-operationalization of Article 370 is permitted if the proclamation had been approved by the Parliament prior to such irreversible action. C. The President reserves both legislative and non-legislative powers after the proclamation of emergency. Though Article 356 is continuance of Article 356, the former does not stipulate any bar or restriction on the Union Parliament or the President to exercise non-legislative power of the state legislature. And I've dealt with the challenge to Section 3 and 4 of the Jammu and Kashmir Reorganization Act. A. The challenge to Section 3 of the Jammu and Kashmir Reorganization Act on the touchstone of Article 3 is not required to be debated on account of the assurance on behalf of the Government of India that statehood of Jammu and Kashmir would be restored on elections being held. B. It is imperative to ascertain the views of the state legislature under the first proviso to Article 3 if the proposed bill affects the area, boundaries or name of the state. However, in the instance case, since state of Jammu and Kashmir was under President's rule and the state legislature was already dissolved, the functions of the state legislature were performed by the Union Parliament. Hence, it was not possible to ascertain the views of the state legislature. It follows that Section 3 of the Reorganization Act is valid. I have penned down an epilogue at the end of the judgment. Uh, Maybe some sentiments involved. The Valley of Kashmir carries a historical burden. It has a social context. Thus, in involving constitutional status of the region, it is difficult to segregate the aforesaid. We, the people of Jammu and Kashmir, are at the heart of the debate. They have carried the burden of victims of conflict for several decades, originating from 1947 with the invasion of the valley. Intervening political circumstances did not permit a redressal to the fullest extent of the invasion. The consequences remained in terms of parts of Kashmir being occupied by other countries. The second round of insurgency holds its origin to the latter part of 1980s. There were troubled situation at the ground level, which was apparently not redressed. It culminated in the migration of one part of the population of the state in 1989-90. It is something that our country has had to live with, and without any redressal for the people who had to leave their homes and hearth. It was not a voluntary migration. The situation became so aggravated that the very integrity and sovereignty of our country was endangered, and the army had to be called in. Armies are meant to fight battles with enemies of the state and not really to control the law and order situation within the state. But then these were peculiar times. The entry of the army created its own ground realities in their endeavor to preserve the integrity of the state and the nation against foreign incursions. The men, women, and children of the state have paid a heavy price. During my travels home over the years, I have absorbed that the social fabric waning and the consequences of intergenerational trauma on the already fractured society. I cannot help but feel anguish for what the people of the region have experienced, and I am constrained to write this epilogue. In order to move forward, the wounds need healing. What is at stake is not simply preventing the recurrence of injustice, but the burden of restoring the region's social fabric to what it historically has been based: coexistence, tolerance, and mutual respect. It is worth noting that even the partition of India in 1947 did not impair Jammu and Kashmir communal and social harmony. In this context, Mahatma Gandhi is famously quoted to have said that Kashmir was a ray of hope for humanity. The first step towards this is to achieve a collective understanding of the human rights violations perpetuated both by state and non-state actors against the people of this region. There have been numerous reports documenting these incidents over the years. Yet, what is lacking is a commonly accepted narrative of what has happened, or in other words, a collective telling of the truth. Internationally, the right of victims of human rights violation and the truth is an end itself. It encompasses a structural investigation of the events and social political structures that led to the atrocity, the particular circumstances of individual suffering, and an authoritative reporting of the results of the investigation. Additionally, truth-telling provides an opportunity for victims to narrate their stories, which facilitates an acknowledgement from those responsible for perpetuating the wrongs and from the society as a whole. This paves the way for reconciliation. While there are different ways of achieving these objectives, Truth and Reconciliation Commissions have been particularly effective globally. South Africa Truth and Reconciliation Commission was set up to investigate human rights violations perpetuated during the period of apartheid regime. It served as a mean of reckoning or a catharsis for victims and fostered peace building. Reflecting on its success, Albie Sachs J. noticed, as a result of the TRC, the private sorrow and grief of tens of thousands was publicly acknowledged to an embracing and personalized way. Another form of acknowledgement emerged from perpetrators themselves. They had to come forward openly in front of the television cameras, owning up their crimes. Finally, there was acknowledgement by the whole country that these things have happened and can happen again, that we needed to fit all these facts together in some kind of significant pattern, which would enable us to understand their genesis and do what we could do to minimize any possibility of their reoccurrence. In the past, calls for setting up of Truth and Reconciliation Commissions have also been echoed by different sections of the valley. In view of the inroads made globally and indigenous requests for truth and reconciliation, I recommend the setting up of an impartial Truth and Reconciliation Commission. The Commission will investigate and report on the violation of human rights both by the state and non-state actors perpetrated in the Jammu and Kashmir at least since 1980s and recommend measures for reconciliation. The Commission should be set up expeditiously before memory escapes. The exercise should be time-bound. There is already an entire generation of youth that has grown up with a feeling of distrust, and it is to them that we owe the greatest day of reparation. At the same time, considering the significance of the matter and under sensitivities involved, It is my view that it is for the government to devise the manner in which it should be set up and to determine the best way forward for the Commission. I am alive to the challenges of recommending of the setting up of the Truth and Reconciliation is beyond the realm of the court. However, I am of the view that transitional justice and its constituents are facets of transformative constitutionalism. Globally, constitutionalism has evolved to encompass responsibility of both state and non-state actors with respect to human rights violations. This includes the duty to take reasonable steps to carry out investigation of violations. It is this context that the proposed Truth and Reconciliation Commission accords with constitutionalism. Our constitution is no different and is designed to ensure that courts offer justice in situations where fundamental rights have been violated. In doing justice historically, our courts have been sensitive to the social demands of our polity and have offered flexible remedies. In Vishaka and others versus State of Rajasthan, this court issued guidelines to address the workplace sexual harassment in the absence of an enacted law, which operated until the Parliament enacted the Sexual Harassment of Women Act. As a word of caution, the Commission, once constituted, should not turn into a criminal court and must instead follow a humanized and a personalized process, enabling people to share what they have been through uninhibitedly. It should be based on a dialogue, allowing for different viewpoints and inputs from all sides. In this context of South Africa's Truth and Reconciliation Commission, Elbe Sachs observed, "Judges do not cry. Archbishop Tutu cried. It was not a court of law in the sense of an austere institution making a highly formalized finding. It was an intensely human and personalized body there to hear in an appropriately dignified setting up what people had been through. There were comforters sitting next to the witnesses. In a court of law, no one is there to help the witness, to pat the shoulder or provide water or tissues when the person weeps. Frequently, the sessions would start with a song in a beautiful African harmony, intended to give a sense of encouragement and support to everybody present. Or it could begin with prayers, and therefore, people spoke and spoke in all regions and in all languages of the country. The testimony was televised, and thus the nation became witness to what has happened and heard the stories directly from the mouths of persons concerned. Those who spoke were not complainants in court, denouncing accused persons in the dock, nor were the litigants demanding damages for themselves, so that the greater the loss, the greater the sum would be received. Taking a leaf out of the South African book, The Principle of Ubuntu, or The Art of Humanity and Inclusiveness should be central to the process. This will facilitate a reparative approach that enables forgiveness for the wounds of the past and forms the basis of achieving a shared national identity. Needless to say, the Commission is only one of the many avenues towards the goal of systematic reforms. It is my sincere hope that much will be achieved when Kashmir opens their hearts to embracing the past and facilitating the people who were compelled to migrate to come back with dignity. Whatever has been, but the future is ours to see.
A judgment is a decision which gives reasons to arrive at and reach a conclusion. By that stretch, my order is not a judgment. We have only two judgments. Both judgments are in seriatim, and seriatim and uniformly agree that Article 370 of the Constitution of India was a feature of asymmetric federalism and not sovereignty. Article 370 was enacted as a temporary provision and did not have a permanent character. The abrogation of Article 370 does not negate the federal structure, as citizens living in Jammu and Kashmir do and will enjoy the same status and rights as given to citizens residing in other parts of the country. Paragraph 2 of CO 272, by which Article 370 was amended by taking recourse to Article 367, is ultra-virus and bad in law, albeit it can be sustained in view of corresponding power under Article 371D. More importantly, Article 370 has been made inoperative in terms of Clause 3 to Article 370. Lastly, CO 373 is valid. I have agreed with what Justice Chandrachud has said, Chief Justice has said with regard to Article 356 of the Constitution of India. I have also made reference to Rameshwar Prasad and others versus Union of India and others, with which I respectfully agree. I also agree with the conclusions recorded by Dr. G.Y. Chandrachud, taking record of the statement made on behalf of the Union of India for restoration of the statehood of Union Territory of Jammu and Kashmir while upholding creation of Union Territory of Ladakh. Then I have agreed with Justice Kaul with regard to interpretation on Article 370, Clause 3.
ये है ब्रिटानिया बर्बन, चॉकलेट 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 बिस्किट। और ये है ब्रिटानिया बर्बन चॉकलेट 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 बिस्किट वाला मिल्क शेक।
Britannia Winking Cow Bourbon Milkshake.
I beg to appear for the petitioner minutes. As per the office report, service is completed.
We can transfer that. The 6 Filed as well.
Yes, my lords. And the distance is around 680 kilometers.
680. You wanted to be transferred from Dharwad
From
to the
Dharwad,
family
Karnataka
court
to
at
Coimbatore, Tamil Nadu.
Right. We'll allow the petition.
Yes, ma'am.
Item 2.
Much obliged.
You want to be transferred from the principal court, family court at Satna to Allahabad, 200, the 2-year-old daughter as well.
Yes, my lord, I am petitioner. Why?
Nobody's appearing. Should we transfer?
Because I am appearing for the respondent, my lord.
Yes, you are appearing, Mr. Pandey, online?
My lord, I am appearing for the respondent wife, my lord.
Yes. Yes,
My
Mr.
lord, I have a prayer that since both the husband and wife have filed a divorce petition at their respective places, my lord, if may I request for mediation, my lord, because the parties have stayed together only for a period of 3 months, my lord, and thereafter they have separated. And both have filed a divorce petition, so my lord.
Why don't we do this? We can transfer it to Allahabad and request the family court at Allahabad to make all efforts for mediation at Allahabad.
My lord, mediation was tried before the courts in Allahabad, my lord, in the 125 proceedings. However, it failed, my lord. Therefore, I am requesting that if it could be taken up at this court only, my lord.
My lord, nothing is remain. Two petition is pending between the parties at Allahabad and
So
both petitioner.
why don't we refer it to the Supreme Court Mediation Center?
Yes, my lord. I have no
The
objection.
parties may appear before the Supreme Court Mediation Center
Yes,
in virtual mode, and
Yes,
we'll
ma'am.
keep it in the second week of July here. In the meantime, if they settle it, so much the better.
Ma'am.
Learned Counsel appearing on behalf of the contesting parties have agreed to explore the possibility of a mediated solution to the dispute, the matrimonial dispute. Full stop. Parties shall accordingly appear before the Supreme Court Mediation Center at 2 p.m. on
After 2 p.m.
at 2 p.m.
After 2 p.m.
After 2 p.m. may mean even midnight, right? So we'll say 2 p.m.
2 to 4.
Right, 2 p.m. But on which date?
Any Friday, my lord.
Mr. Pandey, which date?
My lords, we are comfortable with any of the date which is being given by your lordships and which is convenient to the petitioner.
Next Friday.
My lords.
Initially in the virtual mode. Thereafter, they shall abide by such directions as may be issued by the mediator for physical presence.
Please.
My lord.
List on. That could be put.
Item 3.
May I please, Lordship, I am in this matter for the respondent, and my instructions on the clients are that it may be settled in mediation, your Lordship, so.
I have no objection, my lords. Even I have instructions that matter may be
So
referred to
then,
mediation.
same order as the previous
Yes,
matter.
yes.
Next Friday, they'll appear before the mediation center of this court.
Yes, ma'am. My lords, it can be on Thursday because.
Thursday, sure.
Thursday. Anytime, my
Next
lords.
Thursday, parties will appear before the mediation
In
center.
the
at 2
hybrid
p.m.
mode, your Lordship, so
Yes.
that if the.
We have said presently in the virtual mode.
Please,
Thereafter, they may appear physically, but at least the first hearing, because we are keeping it after 1 week.
please, your Lordship.
All right?
So I have not filed my counter also, so that my clients, please, your Lordship.
Better not to file your counter right
Please.
now. Let the mediation start.
Item 4.
What is the date you,
Next Thursday.
next Thursday,
And
2
we keep
p.m.
it in the second week of July so that we'll have the mediation report in the meantime.
Much obliged, your Lordship.
Item 4
Your Lordship, as per the office report, the service of notice is complete on the respondent, but no one has entered.
is from
appearance.
Haridwar to Kanpur, right?
Yes.
We'll transfer this.
Item 5.
This is from the family court at, there's a 6-month-old infant. Who's for the respondent?
The respondent, lords.
Who's here for the respondent? We'll transfer this from
I would
Haridwar to
request
Kanpur.
for mediation, lords.
Let's try mediation.
Because
We'll
the
try
baby is
mediation
really
once.
small and difficult for her to come out right.
Because they have already been requesting for transfer to
The
Delhi.
6-month-old infant, she's saying now for her to come with the infant here for mediation is also difficult. Should we transfer it to Kanpur? There's from Lucknow to the
Lucknow to
Tisari.
Delhi only.
And we'll say mediation in Tisari.
Yes, your lordship.
That's much better.
Yes, your lordship.
So, and last sentence may mediation before the Tisari course.
Much obliged, your lordship.
So with that, we come to an end of the ceremonial bench. Before we request all of you to say a few words, Mr. Sibal, on behalf of us all, heartiest congratulations on your being elected as the president of the SCBA. We look forward to your cooperation and the members of the executive committee.
It's my honor, in fact, that after 22 years, I've been given the opportunity to serve the bar. And from our side, you will have complete cooperation.
Thank you, Mr. Sibal.
And that's our commitment to the bench, because it's through this cooperation that we can take the agenda, the nation forward. Thank you very much.
Mr. Attorney General, would you like to say a few words?
Coming from one of the most beautiful parts of our country, Coorg, and from beauty comes sweetness. I was just trying to recollect an event soon after my lord's appointment. I had gone to a place called Talakaveri, which is very near Lordship's birthplace. The temple, I went there, and the head of the temple asked me, knowing that I'm practicing here, you know Justice Bopanna? I said, certainly, he's one of the most dwells in the court. So I got a VIP treatment in the temple immediately, courtesy just so. I remember how the impact on people, common men like him, I can understand what the judge in the High Court would have had. And I tried to recollect, on a very small event, a lot of things I can say about the sweetness. I've tried to reserve it for the evening SCBA function. One of my juniors, sometime last November or so, just Bopanna, the court had almost risen, waiting for the counsel to come. I think Aishwarya Bhatti was to appear. No one was in the court. She came rushing into the court. Bopanna was about to leave, almost leaving the court. So I believe he saw her rushing in, and he said, you have the power to hold the court on. I'm coming back and to do justice. What a beautiful gesture on his part. She says something I felt so happy about it. I think that's the way the court, encourages people like us to feel very, very beautiful and part of the great institution. I thought I'll tell her that I'll narrate the incident in the court, that she also feels very good about it. There are a lot of things to say about this Bopanna, sir. I'll reserve it for the evening. And I've also penned something in Kannada for the evening function.
Oh. So then I have to match up.
That's right.
Mr. Solicitor General.
Lords, we would miss your lordships, especially your lordship's very cool and calm demeanor in the court. But most my lord, importantly, my lord, we have on this side, my lord, always experienced a very subtle sense of humor, which your lordships have always exhibited. But that would always be missed. While even in the midst of a very seriously or hotly contested matter, your lordship's humor used to play the role of a calming my lord, presence, my lord. Lord, I wish your lordships a very successful next inning, my lord, and more particularly, a very healthy life, my lord, and a long life. Thank you.
Mr. Accessible.
Thank you, Chief Justice. What can I say? I must share with you something that happens to us every evening while you were on the bench. Because when a matter comes up, we ask, which bench is it? And when we hear it's before Justice Bopanna's bench, we heave a sigh of relief.
Blood pressure depends upon that.
The reason, I give you the reason. You epitomize serenity. The serenity of the ocean and the depth of your generosity. I've always felt that coming in your court. And I've never gone away disappointed whether I win a case or lose a case. Hear us with exemplary patience. Never get swayed by what we do in court occasionally. But that's the beauty of the law, and we believe that it is this that gives us the confidence that this court is the court where we will get justice. Thank you very much for being what you are. All the best for the future, because what you did here will remain with us for many, many years. Thank you.
Mohana.
To say that, Lord, it's always been a pleasure on behalf of the entire women bar and others as well, my Lord. I'm expressing the sentiments that whenever we got an opportunity, like Mr. Sibal would say correctly, but we always look forward to appear in that court, Lord. And junior, senior, it doesn't matter. Whoever wanted to say anything, without modulation of the voice from the beginning till the end, Lord, your Lordship will observe entire proceedings and then pass orders equally. And with the same kind of equanimity, he'll be passing all the orders. Now, the juniors also felt very, very comfortable in appearing your lordship's court. They feel so comfortable, and also, my lord, they feel so encouraged to come and appear before your lordships. For the brief spell that your lordships were not holding the court, we would go around the courtroom and then see when your lordships will be returning after that. So there was an indirect prayer for your lordships to return soon. So we also hope and pray that, Lord, your lordships have a very healthy and a peaceful return life.
Thank you. Mr. Hegde.
Lords, I rise with the rest of the bar to pay tribute to my Lord Justice Bopanna's career here. My Lord comes from a small district of my state, but that district has produced so many great leaders. The first chief, the army chief, Justice Field Marshal Cariappa, General Timmaiah, and that people from that part, it took a long time for Justice Bopanna to make it to this court. And he has shown us the beauty of not only court, but of the state of Karnataka in his classic delivery, in the way that he has conducted the court. We are all very grateful for his courtesy, for his even demeanor, and we wish him a long and happy retirement, my lords, and a healthy retirement. Thank you very much for your service.
Mission 9.
Somebody else seems to have said what I wanted to say, but the only thought that came to my mind was if one asks a question, who is an ideal judge? I think the first person in my mind would be Justice Bopanna. He's so calm in the court and he has a very good sense of humor. And I have, while appearing before him, I have seen there will be a very good joke cracked, and it has been a wonderful experience appearing before you. And even for us, we used to be thrilled when our matters were going to be listed before him. And your lordships, we missed you for those months. Even for us, it's a great loss, those 6 months. But we wish you all the very best and a very, very healthy life ahead, your lordships.
Thank you. Thank you, Guruswamy.
Justice Bopanna, being in your court felt like feeling the sunshine on a cold winter's day. For your serenity, as Mr. Sibal said, your legal acumen, your affability, and your humor. I always walked out of your court, irrespective of whether I got a favorable or unfavorable order, smiling. So for being that sunshine, thank you. Wishing you much laughter in your next innings. Wishing you good health. And I hope you'll entertain us once in a while over a cup of tea, because I personally would love to feel that sunshine once in a while. Wishing you all the best, sir.
Mr. Dave.
Lords, this is not about the appearances in court. There was an unofficial poll that was conducted in the Supreme Court as who's the most popular, good-looking, calm, intelligent judge. And I'm sorry, I don't mean any disrespect to your lordship. If the proportion of the population...
If you said something about us, we would be thinking, which matter does Mr. Dave have on court today?
If the proportion of that population to the popularity of Justice Bopanna, who led, like Mr. Sibal yesterday, my lords, it's more than Amitabh Bachchan, Shah Rukh Khan, and I don't want to be discriminating against the southern states, my lords. So all the people, my lords, I would only request Justice Bopanna, if he can, just walk in the corridor today, being the last day, come for a cup of coffee to the canteen, and please assess the popularity that your lordships have amongst the member of the bar. I would like to thank your lordships for coming to this court and enriching all of us. Oblige.
Nicest judge you have listened to the Supreme Court.
Mr. Vaidyanathan.
The collegium had looked for an ideal model for selection of a judge. That we have always found it a pleasurable experience to appear no stress, no tension. And then I think whether it is junior or senior, everyone has had a very patient hearing, but at the same time, no beating around the bush and very firm and decisive judge. And that's what I'm very, very.
Lord, Mr. Hansaria.
The Attorney General said, my Lord Justice Bopanna comes from beautiful part of the country, my Lord. My Lord Justice Bopanna has been the Chief Justice of another beautiful part of the country, my Lord. And Guwahati High Court Bar always remembers your Lordship, Lord, with great benevolence, with great respect, my Lord. And none of the members of the bar has gone with a sense of dissatisfaction, whether you will lose, as Mr. Sibal has said, my Lord. All of us has gone out, the members of the bar, even the litigant public, my Lord, because now they watch the proceedings. And we are extremely grateful for your Lordship, Lord, to keep the fly this board of hanging high, very high.
Mr. Agarwal, you want?
My Lord, on behalf of SCBA, I can safely say that Justice Bopanna has been kind to every member of the bar. And we will always miss him. We will always, but invite him to see Kejrival. And I have congratulated, as Lordship has congratulated Mr. Sibal. I also went to his house last night. I was the first to congratulate him and garland him.
Before I request Bopanna to say a few words.
On behalf of Scora, I only say that the first judge from Kurk to occupy such a high post, as Mr. Hegde had said, two wartime generals from Kurk and a man of peace in Supreme Court. And his weapon was his gentle smile. And they were in his court, it was like Buddha's garden. Nobody was raising voices. There were no raised pitches. And both parties came satisfied. All I say, my Lordship has expressed his view that he would go back to the hills. And whenever you have your morning's filter coffee, please remember Delhi, please come to the Yamuna. We all need you as a mediator and arbitrator in Delhi. Best of health and best of happiness. Thank you.
Your Lordship.
Somebody online?
Yes, Lordship. On behalf of Supreme Court Bar Association, as a secretary, I must tell you, Lordship, about Justice Bopanna. In lawyer's corridor.
Rohit, why don't you unmute yourself on the video as well?
1 second, Lordship. I'm so sorry. There is a problem.
Okay, you can say what you have to say. No problem.
But I must tell you about Justice Bopanna. In lawyer's corridor, here everybody is talking and saying that Justice Bopanna is so sweet. So we will miss you, Lordship, and wishing you for your good health and best wishes to your new journey, Lordship. Thank you.
Before I request Brother Bopanna to say a few words, and while reserving my appetite for a more detailed presentation this evening, I would just like to say that Brother Bopanna is not just a great gentleman, a compassionate judge, but he's above all a good human being. And I think that is the heart of good judging. Just to give you one example, in one of those transfer petitions which are typically listed before the ceremonial bench, there was a little resistance on the part of the respondent to do a mediation in Delhi. And prima facie, I also thought that we can ask the parties to mediate before the transferee High Court. But I don't take a decision on any matter before I consult both my judges, and in this case, all three colleagues. So Brother Bopanna looked at me and said, we'll give them one opportunity to come mediate in the Supreme Court. And I immediately realized the wisdom of long experience, where Brother Bopanna felt that after all, a mediation before the Supreme Court may carry some greater weight for the parties than a mediation before the district court. So that's Justice Bopanna personified. Even when there are just 3 or 4 matters to go before he takes his final bow, he treats every matter with the same amount of diligence, dedication that he did on the first day of his appointment to the High Court. Brother Bopanna was in medical leave, all of you know, for a few months. Every time I called him up to find out how he is, he would be first concerned, before telling me about how he is, he would be talking about the Constitution Bench judgment which was pending before us, and say that, Chief, I'll try and come sometime for at least a day or 2 days and we'll pronounce the bench judgment and I'll go back on leave. And I would always tell him that, look, you better get well soon. When I went to his home, his very gracious spouse, Ms. Mona Bopanna, who is here, his daughter, his son, his in-laws, they all congregated there. And we were wondering, I mean, we were there to wish him get well soon, but there he was handing out hospitality to visitors from Delhi, his colleagues from Delhi who would come and meet him during those days when he was in Bangalore. Brother Bopanna, you have been truly a stellar judge of the Supreme Court right up to your last day in the Supreme Court, and truly we'll miss you. When I offered Brother Bopanna an assignment post-retirement in one of the tribunals, because we are in need of good judges to man some very important tribunals, he looked at me and said, Chief, please liberate me from that thought and let me go back and do something else. I don't know if he really wants to go to the hills or whether he will do what he has to do, which is that he'll be in such great demand as an arbitrator, because he's known to be a judge of the highest standards of integrity, independence, competence, proficiency. So I don't think, Brother Bopanna, that the bar in Delhi is going to let you off so quickly. And we do hope that you will be part of us and continue to do good work even hereafter. And speaking for myself, we'd like you to be continued in your association with us over here. Sitting on the bench with Justice Bopanna, he would just whisper something, in the midst of a matter, and whisper it with such a great deal of understudied elegance. And that was the beauty of sitting with Justice Bopanna. He would never make a point with aggression. He would say something just in a half a sentence, which summed up perhaps that strategy for doing justice in that case. And I think, sitting on this side of the court, that means so much to the Chief Justice, because as a Chief Justice, there are 200 things going on in your mind, something administratively, but for that moment, you're focused only on that case. And having an able ally like Justice Bopanna, both as the Chief Justice and the Collegium as a senior judge, meant really a lot to me as a Chief Justice. And thank you very much, therefore, for all your cooperation and your association with the court, and for your friendship, Brother Bopanna. We wish you all the best for the future. May I now request Justice Bopanna to say a few words.
I don't know really what to say. Honorable the Chief Justice, Justice Dr. Chandrachud, colleagues on the bench, Justice Parjiwala and Justice Anuj Mishra. Learned Attorney General, Learned Solicitor General, Mr. Kapil Sibal, President-elect, President of the Bar Association, and all learned senior counsel who addressed. The thought now is, after probably till yesterday, day before, I thought it's only a day of retirement and then I'll be quietly retiring. But the day I was called to Torah Association, when I realized the affection, after that I'm a little emotional. Anyway, I mean, all these good things, what you have said, I don't know how much I deserve. But then when all of you are saying, quietly at the corner, I was just looking at my wife's face. She wasn't surprised, she wasn't astonished, nor did she think she's in a wrong program. So I acknowledge whatever you have said, there's a problem there. So I acknowledge what you have said. And I thank you for all the sentiments. And now I can only say thank you and goodbye. Because evening we will be probably meeting. Many of you may not be, but we will again meet, because I also know that the chief has about 81 matters in his list to complete. I will not take much time of yours. If I have been of some service to all of you, to the country, that itself is the greatest satisfaction which I carry with me. So let me thank you all once again. Goodbye to all. Until we meet again.